We're about to embark on the second part of our presentation this morning, in which Simon Minahan will discuss, with a principal focus on the intellectual property aspects, two cases. The first, the decision of the High Court in Roadshow Films against iinet. His notes on these two cases were distributed in the material which was made available before we commenced this morning. And Simon will also examine the case which spawned the case to which Georgina took us, the Demetriou case. That was the case in the federal court of NRL investments against Singtel Optus. That was the appeal from Justice Raries, which held that Optus had not infringed the content of the football codes, and that was reversed on appeal. And as I understand it, there's presently an application by Optus for leave to appeal. My understanding, and Simon will inform us about this, is that that application has not yet been dealt with. But as I've already indicated, and as appears from his profile, Simon is particularly well qualified to explain the mysteries of these cases in this still evolving area of technology. So I'd ask Simon to address us now, and as I said, at the conclusion of his paper, we'll have an opportunity for questions and discussion.
Thank you very much, Tom. I will start with the Optus case, since that is the one we've touched upon in Georgie's speech. And I'll open with the observation that in all IT cases of any significance, in my estimation, one needs to take the time to understand the basic workings of the technology, because that's the factual matrix on which the law will act. And very often what appears to the user is not necessarily an accurate reflection of what is in fact happening mechanically. And therefore your fact situation may be what we call counterintuitive. In the Optus case, the situation is that Telstra and the NRL, I beg your pardon, and the AFL, amongst others, had struck a deal whereby owners of smartphones were able to access live footage of selected games, and these games were also being broadcast free-to-air. Now, there are particular provisions dealing with rebroadcast of free-to-air transmissions, and they are not especially relevant to this case, simply because what was being done was not a broadcast, it was, if you like, a narrowcast or a subscription cast to Optus subscribers. And what Optus had decided to do was exploit a provision, Section 111 of the Copyright Act, which was introduced a few years ago now, probably about 5 years ago now, which provided a limited right, which hitherto had not been provided to Australians, to make a copy of for domestic use, a copy of broadcast TV shows or films for the purpose of watching them at a more convenient time, what is known as time shifting. That's a right that had been in existence for a long time in America as a trade-off for paying a levy on videotapes and recording media as a way of compensating the copyright owners in television broadcasts back in the 60s and the 70s, where there was a lot of argument about whether video recording machines and the like were the devil's work and effectively devices designed specifically to enable infringement on a mass scale. Well, if video recorders were so viewed, you can imagine what the internet and digital devices are viewed as in the eyes of copyright owners, since they are, in one description I've read, essentially the internet is one enormous international copying machine. Now, the provision in Australia went through a bit of an interesting history, and that history is important in this case because what it provides, and I've set the provision out in the notes, and it says the section applies if a person makes a film or sound recording of a broadcast solely for private and domestic use by watching or listening to the material broadcast at a time more convenient than the time when the broadcast is made. And secondly, the making of the film or recording does not infringe copyright in the broadcast or in any work or other subject matter included in the broadcast. So, that's your permission. Specifically limited to what we call time shifting and for domestic or private use. In draft, in the bill form, it was also a condition that the recording was to be made on domestic premises. That was elided, and a further explanatory memorandum was issued with the amendment, which actually referred to the possibility that you might do it remotely, i.e. you might engage a service to do that for you rather than doing it on your own system. Now, that was very relevant to this case, and it's very relevant in a broader context to what we're now seeing by way of cloud computing and these sort of distributed applications that have been around for a long time but that are taking off right now, particularly with Apple developing so heavily that side of its business model. So Optus, with an eye to the main chance, very deliberately designed a system to try and take advantage of this rule. And when I say very deliberately, it was very carefully done and very carefully minuted, and the system was expressly designed so that Optus maintained all the servers, and any of its subscribers to the TV Now service could elect to record by pressing on their smartphone or their computer a text button that said record now, and I'll play it back, and they'd hold it for 30 days, at the end of which it was to be erased. It did not, Optus did not simply record and make available later. It only recorded on request, and it recorded specifically for each user. So its argument therefore was that we are simply providing a facility and the user is the one who triggers and makes the recording. And that is the nub of the case in both trial and at appeal. Who was the maker of the recording? Now, one thing I think that was perhaps sidestepped to some extent was whether in fact, because what the system enabled users to do was not just time shift and watch it an hour later, you could watch it a minute after the original broadcast. So effectively, you could watch it live to air with a delay of 1 minute. So it was a way of getting around, and this is what so aggravated the applicants. It was a way of getting access to a service that you otherwise had to be a subscriber to Telstra to get, and for which Telstra had paid a considerable sum to the AFL, and on which sums the AFL was banking not just now but into the future. So there's a lot at stake commercially for the AFL. The question is, are Optus doing the wrong thing, or has Telstra simply paid too much? In a commercial sense, it's not a legal question, obviously. So the question was, on a below, His Honour had found that, in fact, the subscriber was the party making the recording and likened the apparatus and the servers and all the mechanisms of Optus Optus made available to the user as essentially a video recorder, which the users press the button for. The analysis in terms of infringement was under a provision introduced in 2000, which is to communicate to the public a work or a non-work, in this case a film, which was introduced specifically to deal with digital broadcasting. And there was no question in this case of authorisation or the issue of secondary infringement. It was just a question of whether Optus infringed or the user infringed or both infringed directly, because Optus controlled all the equipment, and in taking the broadcast and making a copy of it, they were making a film within the definition of the Act, and then retransmitting that film via the telecommunication service digitally, so therefore breaching the communication right under Section 86. So in short, the judgment below was the user is the one who has the last volitional act of choosing to record, and the apparatus is, if you like, inanimate. And therefore the court below said we will regard the user as the one who makes the recording, and the recording is otherwise within Section 111. It's for domestic or private use, and therefore there is no infringement. On appeal, the full court takes a different view of the definition of the words make, and goes through an interesting excursus of American jurisprudence around notions that aren't entirely opposite, and says they're not entirely opposite to the analysis here, although they've been referred to quite a lot because the Americans have notions of contributory infringement, which involve similar ideas, but we don't have a similar response or a similar remedy. In the end, the court takes the view that, well, the full court takes the view, yes, the trigger is pressed by the subscriber, but if you take just the normal use of the word make, it is Optus who puts all the equipment together, it is Optus who runs all the equipment, it is Optus who keeps the recording, it's on their premises. As far as the full court's concerned, that's enough to say Optus makes, or at least Optus and the subscriber make that recording together. Now that is on, at least there is an application for special leave pending, and I have probably, I'd be surprised if it didn't go up, but one shouldn't anticipate. I think one thing that's very interesting in it is, or a little interesting, but in context of the next case we discuss, it's interesting, is that there is a call at the end of the reasoning to say, please, can the legislators work this out and not leave it to the courts? A cry which is echoed even, perhaps even more strongly in the second case, which I'd like to discuss briefly with you, which is the Roadshow and iinet case. A decision of the High Court involving, again, copyright infringement claims in relation to an ISP. In this case, the claims were that discussion of the concept of authorisation. Under the Copyright Act, those rights that are reserved to copyright holders, such as to copy or to communicate to the public, to reproduce or communicate to the public in terms of films, which this case concerned, are also encompassed, the primary rights also encompass the right to authorise doing those acts. So the Act provides that that is a direct infringement, although in the parlance of the judgments and generally as a way of distinguishing, it's called a secondary infringement. It doesn't occupy a secondary rank in terms of its treatment in the legislation, but just as a means of identifying its nature as an accessorial type of claim, it's called a secondary infringement. Now, by way of background, iinet, at the time of the commencement of these proceedings, 2008-2009, I think was the third largest ISP in Australia. It had nearly 500,000 subscribers through 2008. those subscribers naturally use it to access the internet, and the analysis that was done at the time of the traffic and the use that people were making of that access to the internet was that almost half, in fact more than half, by volume, of their activity on the internet was engaged with a program called BitTorrent. Now that's a massive amount of time. BitTorrent is a peer-to-peer file sharing program that was designed in 2001 in the wake of other failed or at least superseded mechanisms, which is distributed amongst users. It's a little program you download. There is no central warehouse or communication point to which it refers you, but what it does do is link you with other users who have the program and enables you with them to collaborate and share files, including movie files and music files. Now, all this is common knowledge, I'm sure, to most of you. But to think that almost more than half of the activity of the ISP in 2009, I think it was engaged in this file sharing, of course, without payment of copyright material. Copyright owners, and in this case there were 39 applicants, all essentially from the movie and TV industry, Warner's, Sony, Roadshow Village, represented by an enforcement arm called AFACT. They preferred to target, understandably, the ISPs as a natural collection point rather than try and chase down each individual user, which is a complete nightmare. So the question for them and the court was, well, has iinet authorised this conduct? Now, you'd probably be aware of the jurisprudence around authorisation. It's been an issue for a long time, and it's been an issue that had to respond to this sort of disruptive technology as an expression that seems to have gained increasing currency recently with the Murdoch appearance at the Leveson inquiry. He was very taken with the term. He must have used it several times, I think, half a dozen times, referring to the internet as disruptive technologies. And I noticed in the judgments there's a reference to it as well, in a fairly disparaging way, as if it was naughty, that it had upset the apple cart somehow. So the issue with the authorisation arose in Morehouse to do with photocopying machines, as we're aware, and authorisation as a concept goes back to, in the Act, goes back to 1901, and it received fairly early gloss where the Oxford English Dictionary was resorted to, and the definition there was to approve, sanction or countenance. So a spectrum from very positive approval to merely allowing, by omission, some conduct to go on. And it's been accepted for some time in the courts that that spectrum of behaviour may constitute authorisation depending on the circumstances, depending on the relationship between the parties, the direct infringer and the party accused of authorising, and depending on their state of knowledge. AFACT had to rely on essentially that end of the spectrum, namely the countenancing end of the spectrum, for a couple of reasons. One, there is no requirement on iinet to actively police what goes on their on the service they provide. In fact, they couldn't do it, and they are afforded some coverage as carriers, as in the telcos are common carriers, so long as they're merely providing facilities. There are defences in the Telecommunications Act and under Section 112E of the Copyright Act for merely providing a facility without more. So, secondly, they had, as a matter of fact, in their CRA, in their customer relations agreement, so their agreements with their users, provisions that said you will not break any laws, infringe anyone's rights, and we have the right to kick you off if you do. Now that became crucial in the case and it's remained crucial all through. Thirdly, while it's common knowledge that there's this sort of usage of BitTorrent going on, in order to fix them with liability or try to fix them with liability, you have to, the stronger the knowledge, the more specific the knowledge of the conduct, the more likely you are, given inactivity, to make a case that will get you home on liability. So AFACT and the American arm proceeded to, in preparation for the case, monitored the BitTorrent activity of iinet users and proceeded to send notices to iinet informing them of what they alleged was infringing conduct in respect of given movies. And when I say they sent notices, they generated them automatically through an American arm and more specific ones through an Australian arm. In 1 week in December, iinet got over 1,100 notices in 1 week alone, listing raft of infringements. And each of those notices had a schedule of users, or at least not actually users, their IP addresses. Now, just a brief word on that because it's important to understand the way that works. The IP address, ISPs get a bundle of IP addresses from the authority that regulates that and allocates them to their users. If you're a commercial business that's online all the time, you get a permanent IP address, but if you're a private user, more than likely each time you log on, you'll be allocated a different one. They just go through and rotate them around. Of course, that will be only to the point of connection between that computer and the ISP, and there may be a network of users on that end. So one IP address may not represent one user, it may represent many users. So iinet, having received all these notices and demands from Roadshow that it start telling its users that under the terms of their contract they were infringing, and if they didn't stop infringing they would be suspended or their service terminated. And iinet's response was, we're not the police, you're not the police. If you were a prosecuting authority, we'd have a duty to help you, but you're not, and we don't. And what's more, these notices are opaque. We'd need to do a lot of investigation to make good any of these allegations before we felt comfortable in terminating. We don't feel comfortable and we're not going to undertake the investigation. AFACT commenced its proceeding. And they have lost at every stage. From go to woe, the finding has been that the inaction of iinet was reasonable in all the circumstances, not least because of the quality of the information with which they were supplied. But in the High Court, it was reduced down to a more limited compass than it had been below. There had been a number of secondary issues such as whether the safe harbour provisions and so on could be afforded. But in the High Court, it was really reduced down to the question of authorisation and the analysis of section 101(1)(a), which codifies some of the concepts of authorisation. And in particular, whether or not Optus, iinet had the power to prevent these infringements, and whether one has to have the power to prevent in order to be made liable for authorisation. Believe it or not, that question had been a little up in the air. The High Court settles it completely and says, yes, you must have the power to prevent if you're going to be held liable for authorisation, but that the contractual power to take these people offline was not sufficient. That was not a power to prevent, and that iinet, because they didn't store the information, the users by BitTorrent do it between themselves, they didn't distribute BitTorrent, and therefore they weren't distributing actually the means of the infringement. The access to the internet was not equated with the means of infringement. And they didn't have any means of controlling or modifying that program. In all those circumstances, the High Court said that iinet did not have a direct involvement and did not therefore have a power to prevent, and that the power to take people offline was not the same thing, and observe that, in fact, that was a wider response than the applicants would have got by way of curial relief. Like, a court wouldn't have ordered, except in very extreme circumstances, that all these people lose their internet connection. They would simply have been enjoined from making further use of, not even making further use, from further conduct infringing people's rights. So the industry behind the push is, of course, not about to let that lie, and they perhaps got a fillip, even though they lost the case, in that the two judgments delivered both contain very explicit and very heartfelt, if I can put it that way, pleas to the Parliament to get involved and resolve this issue. They essentially take the view, certainly in the lead judgment, that the situation's unfair on the copyright owners, but that we can't resolve it by shunting the burden onto the ISPs, or at least, if you want to do that, you need to do it more expressly than it's been done. Curiously, that plea in one of the judgments is prefaced by observing that in 1968 the Copyright Act was 100 pages long, and it is now over 500 pages long. That we've had major rafts of amendment to that Act and addition to that Act in 2000 and 2006, but nonetheless that we need to go back and do more. And that against a policy, certainly as pronounced in 2000, that was light touch. We shouldn't do too much. We should let the common law deal with it. Well, the common law has come back and said, we shouldn't be dealing with this, you should be. And that's perhaps not confined simply to this element, but I think we've seen hints of it really in the database area as well, with the results in Telstra and desktop, and then the subsequent changes to that in ICE-TV, where there was a significant correction of policy in the judiciary's approach to that, and I think a recognition that we need, again, more specific legislation in that field, which leads us to the unhappy prospect of, at some stage in the next short period, another round of amendments, and those amendments being driven by the parties most interested with the most money, being the copyright owners' lobby. So we await with bated breath the outcome, even though in the long run, at least some of the questions about authorisation are settled by the case notes, and there's a lot more detail in there that I haven't got time to describe with you now, but hopefully the paper that's been handed out will clarify some of that. Thanks for coming out.
Well, thank you, Simon, for that very perceptive analysis of those two quite important cases in this area. As I indicated at the outset, the topics of the papers are now open for questions or comments from the floor. You can address questions to either or both Georgina and Simon. Please don't address anything to me, because I'm probably even more ignorant of these topics than you are. So it's open for questions and comments now.
So much mud was thrown at sanction approved countenance as explanations for authorise and discussion of grant or purport to grant as an alternative. In the end, is the High Court authority for proposition for a new test for authorisation?
It's certainly, what Chris is referring to is the classic formulation, and I did allude to it, was this sanction, approved sanction or countenance. And the High Court does disparage reliance on the dictionary definition without more. And there's a rather wistful glance in both lines of the judgment to another line of analysis that was developed in parallel but seems to have withered until now, which was something more along the lines of an agency analysis, i.e. to authorise would be to grant the right or to purport to grant the right. So something a bit more positive than merely standing back and watching events unfold. I think the reality is that each of the cases is going to be fact-driven, and I don't believe for a second that the door has been closed on approved sanction or countenance. If you go back through the history of the cases, a lot of them involve bands playing music in pubs and playing songs in breach of copyright of the song owner, and the pub owners being sued on the basis that they knew, or at least they gave the premises, but they didn't have any direct knowledge. So I think the courts will want the ability to resort to some line along a spectrum. I don't think that's changed. Yeah.
Georgina, in the paper you presented, there was a reference, I don't practice in trade practices, or what used to be trade practices, but there was a reference to misleading conduct in employment. And there was a case recently where some high-profile person had to resign or stand down because he falsified a claim that he'd obtained a certain degree before he was appointed. If, for example, looking at it in a commercial context, somebody came up to be, say, a director of a company and failed to disclose something, such as prior conviction or being held in breach of director's duties or something that impugned his ability or integrity or honesty, would his non-disclosure of that, for example, even though his employment hasn't commenced, would his non-disclosure of that be caught under the section in the Trade Practice, or the Act that is referred to by you, Section 31, I think it was?
Well, I'd have to take several hours at an extremely high rate to answer that question. But having a guess, I'll address it just in general terms about misleading or deceptive conduct and refer to the point that was made in Optus and the AFL, which is that it has to be in trade or commerce and not in relation to trade or commerce. And so I think an important distinction would be whether that misrepresentation was in the course of the person negotiating to get the job or having the job with their employer, so that it was in relation to that transaction, that employment transaction, as opposed to misrepresenting your qualifications and misleading a broader audience. That wouldn't be within the transaction between the employer and the employee. But beyond that, I'm afraid I'd have to look at the legislation and consider it.
It just occurs to me that there is a long line of old non-disclosure cases, particularly in the federal court. There's one which was a decision of the full court, which was presided over by the former Chief Justice. I can't recall the name of it offhand, but my view, those cases would still apply. But as Georgina says, it still depends on the context in which the representation, whether it's by non-disclosure or positive assertion, occurs.
Simon, David Levin, you're probably familiar with the Mr.com situation in New Zealand. Does that have a parallel to the iinet decision in the High Court?
I'm not super familiar with it. I've seen some reports. So,
right.
What's the detail?
I mean, as I understood it, BitTorrent was the issue, and he was sort of through his corporate entity carrying about a quarter of New Zealand's traffic, and the authorities have got very annoyed about it. But I didn't know whether the New Zealand legislation, to your knowledge, was going to reflect what had happened here.
I don't know the answer. There is an increasing uniformity, though, around the world in the legislative responses driven by the American interests. We got a lot of our current legislation by virtue of the free trade agreement with America. No sense of irony, really, calling that a free trade agreement. But so I imagine that it is a similar case, but I'm guessing. I'm not familiar with the New Zealand Act.
Actually, Simon, I think slightly dissimilar. Simon, I think in the case of Mr.com and Mega Upload, there is a mechanism that is actually provided, that there are servers that are provided specifically for the purpose of copying, uploading, storing, and then downloading. So that might be the basis for a distinction.
Yeah, although, well, no, that is a distinction because in, and it's certainly something made much of in the iinet case, is that iinet provides no facilities in any sense other than connection. So they're not storing, they're not copying or uploading anything. And the distinction's drawn very expressly with the Morehouse situation where that was a library who was providing the premises, the books and the copying machines, and therefore were much more in a position of a power to prevent. So the analysis is pretty different on that basis. I think they'd be found to have a power to prevent. If you're providing the actual servers, you're much more likely to get sheeted with liability here.
Simon, are you aware of any draft amendments in and running at the moment?
Oh, no. I think it's too early for that. Yeah.
For Georgina, you spoke about, in the context of the trade practices and the Optus case, the expression of opinions and them not generally falling within the misleading and deceptive conduct provisions. You talked about that in the context of discussion of policy and the like. Do you think that this case has a broader application on whether opinions are misleading or deceptive, or do you think that those comments were limited? Because I know there has been previous case law on those issues. I'm not particularly familiar with it, but do you think it has broader application, or do you think it's limited to those sort of opinions?
Yeah, I do think it has broader application because there was a discrete point that because the opinion was reasonably held, even if it was wrong, it can't be held to be misleading or deceptive conduct. It's not misleading to tell someone what you think of something. You might not convince them that you're right, for example. So yes, it does have broader application.
So presumably there's a starting point is to determine whether it's essentially a representation of fact or a representation of opinion, and then because it's a strict liability provision as such. So I guess I was intrigued by the reference to honest opinion because, as I guess we know, with most misleading and deceptive conduct matters, the I guess what you would call the mens rea in the criminal context doesn't really apply.
That's right, and that's something that His Honour did point out, that it doesn't matter about your intention to mislead or not. You might not mean to mislead, but you do, and therefore you can be held responsible. So yes, you make a good point.
I just had a question for you, Simon, about the Optus case. I was just wondering what your thoughts were on the full court's approach to interpreting to make, and particularly section 111, and whether or not they were too literal with their interpretation.
My personal view is they were. It seemed to me that there was a desire for simpler times perhaps behind that judgment. And it seemed to me to completely, not completely, but to significantly downplay or ignore the alteration that was made to the provision in its passage, where the requirement for it to be recorded on domestic premises was explicitly removed and explained as potentially allowing outsourcing, and the court's attempt at negotiating that fact and dispelling it, I find reasonably unconvincing, to be honest, with respect to the court. It seems to me there's significant negative implications for that, for the cloud and for outsourcing all sorts of activity inherent in that judgment should it stand, and it will need to be addressed commercially and as a matter of policy if it remains the way it is. Yeah.
Sorry, I just thought of one other thing in response to your question. I read a case recently, I can't remember the name of it, but in the particular case, someone was held to be misleading or deceptive in the expression of an opinion, and that was where it concerned a landlord in a shopping centre, and it wrote a letter to the tenant saying that the market value of the property was a certain amount, and imposing upon the tenant a very high rent. Now, from memory, that was actually held to be unconscionable conduct, but the issue there is if you give the person the impression, the false, if you mislead them into thinking that because of the opinion expressed, the market rent is a certain amount, then that would be an example where an opinion does mislead a person and could be false or misleading conduct. So I'm not saying that opinions are always safe.
Well, if there are there seem to be no further questions, so I'll thank you all for your attendance and the attention that you've given to our speakers this morning. I think that attention reflects the painstaking work that they put into the presentation of their material and the interesting way in which it was presented. I'd thank also the staff of Greens List for the organisation that goes into events like this, and that's occurred again today. And of course, in particular, I thank our two presenters because, as I've said, it's their work that contributes to seminars like this. So I'd ask you to express your appreciation in the usual way.